Thank you, Mr. Fannin. No further questions.
All right, thank you. Your cross.
Yes, Your Honor. Mr. Fannin, you believe that the defendant was using your numbers for the lottery, right?
Oh, yes, and that's why she won. Because they are lucky numbers. Like, I'm so glad she's using them now because they're in the world and they're gonna make a difference. Oh, I'm so lucky.
Well, you're glad now, but you confronted the defendant about using these lucky numbers, right?
Well, as a joke, really. See, when Lane told me that when I figured out that Lane was using my numbers, I was a little upset because I'm like, I don't want everyone to know these. But when I realized that she was using them, I realized they're in the world now. They're gonna make a difference. So honestly, I should thank her.
You should also thank the defendant because she promised you 1% of those winnings if those numbers were ever drawn.
Well, yes, in words, but it was a joke. See, Lane and I joke a lot. And this particular time, I confronted her as, like I said, just kind of joking around. And Lane said, well, if I ever win, I'll give you 1%. We didn't actually think that she was going to be 1%. See, if I ever got 1%, I was thinking of like one of those fancy lobster dinners from Red Lobster, you know, like the one from the commercial. It's like steaming and buttery and bright. Oh, that would be so good.
However, you never mentioned in your sworn affidavit that you were joking, did you?
Well, no, it's called like an inside joke. See, Lane knew it was a joke, and I knew it was a joke. So, I mean, we understood it was a joke, of course. But it's not an inside joke if everyone knows. It ruins the fun of the joke.
Well, you will agree that if the plaintiff wins today's case, you will lose $200,000.
Oh, no. I would not get any money out of that. I would never take money from a friend. No.
You will agree that 1% of $60 million is $600,000, right?
Yes, if we're doing the math, but I was never going to get anything from it.
1% of $40 million is $400,000, right?
I believe so. Yeah.
$600,000 minus $400,000 is $200,000, correct?
I'm pretty sure. I was never good at math, but I guess so, yeah.
Well, you stayed at work late, right?
Oh my gosh, yes. I had to pull an all-nighter that night. I was so behind on my work, and Tweets was keeping me up all night. So I stayed and did all my work at Workspace, yes.
And on Tuesday, June 26th, you saw the custodians come in to clean, right?
I don't believe so, because my trash can was still full, which actually was really annoying because I like to keep my personal space very extra clean. If it's not clean, then I never get stuff done.
And you will agree that on Monday when you return, you will agree that there was still trash from last Tuesday, right?
I don't know. Well, I mean, I guess so, but there was trash. It was a bad day. I remember seeing the trash and being so upset.
And you will also agree that on Wednesday morning, you had a conversation with Jackie.
Oh, yes. We talked about the weather. We talked about Friday's jackpot. Oh, we talked about my lack of sleep. We did talk about my lack of sleep because I had lost a lot of sleep. And we talked about Tweets. Yes.
And she told you that the Friday jackpot was increasing, right?
Oh, yes. See, as the amount of money in the jackpot increases, the amount of excitement in the pool increases. And at the very end, we're like all excited. Oh, that's why everyone plays the Tuesday pool. It's so much fun.
You claim that you heard her say that she had already directly contributed, right?
I do remember that. I was already a little hazy this morning, but that's the one thing that I remember because it didn't make any sense because I had just put my money on Lane's desk and there was no money under the X-Wing besides my own. And then I checked the notebook and there were no names in the notebook for Friday. And then I talked to Jackie and Jackie said that she had given her money to Lane. And then on my way out, Lane was passing me on her way in for the first time that day. So it had made no sense.
And you agree that you were sleep deprived, right?
I was very sleep deprived, but that's the one thing that stood out because when something doesn't make sense, it makes more sense to me.
And you will agree that on Monday, July 2nd, you cleaned up the scattered trash, right?
Yes. No. Yes.
And you agree that that trash came from Gabrielle Wren's trash bin?
Yes. Apparently it was punted across the room because I did see a crumpled trash can. Like someone had taken a sledgehammer to it. So I did put in a new trash can to make sure that it was safe.
And you will also agree that later on that day, you saw Jackie go to the defendant's cubicle, right?
I did because it kind of annoyed me because we don't go through each other's stuff. It's rude. We don't like to go through each other's stuff, especially because if someone went into my desk, I have a little statue of Tweets that if someone ever touched it, I would be very annoyed. And I know that Lane has her fighter pilot X-Wing, and I know because personal experience, I accidentally knocked it over one time and she was mad.
This witness is being non-responsive.
Your response?
Your Honor, my witness is simply answering the question that opposing counsel asked.
Yeah, the objection is sustained.
Yes, Your Honor. Now, Mr. Fanning, you will agree that you never saw Jackie with the pink post-it note before she went to the defendant's cube.
No, I never saw her with a pink post-it note.
You never saw her touch anything on the defendant's desk, right?
Nope, I was in my own office doing some of my own business.
Well, you agree when you were watching her, you didn't see her write anything.
Oh, I wasn't watching her. I was in my own desk. I was kind of like talking to my little statue of tweets and doing some of my work.
So it's your sworn testimony that you weren't looking at Jackie?
I mean, I glanced over a couple times, but I wasn't like solely focused on Jackie. I have better things to do. Sorry, Jackie.
But you will agree that you saw Jackie run to Sunny's office.
I did see her run to Sunny's office and she was yelling.
And she was yelling, she said, "Aha, I knew it," clutching her pink post-it note in her hand. Right?
She did have a post note in her hand, yes.
Then she said, "I knew she wasn't cheap. Here's my note from Wednesday. I'm going to get my money."
Well, she did say she was a cheat. I do remember that because I don't like to call people names and it kind of hurt my feelings.
Your Honor, I have no further questions.
Can you redirect?
No, Your Honor. May witness step down?
Yes. All right, the defense can call this next witness.
Before I begin, Your Honor, may I retrieve the exhibits I will be using?
Yes, ma'am.
Please introduce yourself to the jury.
Hi, Lane Shipsey.
Tell us a little bit about yourself.
Well, I'm an architect by trade, but I prefer the term cultural curator. And I consider myself an idealist because I became an architect to make the world a better, more beautiful place. But unfortunately, idealists don't get very far out there in the real world, so I'm currently wasting my talents creating unstylish, utilitarian strip malls.
How do you know the plaintiff, Jackie Hutchinson?
Jackie and I both rent desks at Workspace in Carly Corners Village. That's a place where people from any different profession can come and rent a desk. I rent a permanent desk there, and Jackie rents a day-to-day desk. She's an architectural designer, so not really what I do.
Do you participate in any activities with your fellow workspace renters?
Oh, of course. There's the first Monday mixers each month. Those are a blast. That's how I introduced my friend Gabby Wren into Workspace. I'm also the commissioner of the Office Fantasy Football League, sports tournament pick'em pools, and the bi-weekly lottery.
Please tell us a little bit about the bi-weekly lottery.
Well, I organized it because I thought it would be a fun office activity for us. And every Tuesday and Friday, a group of us pool our money and roll the dice. Tuesdays is the big bucks drawing, and Fridays is the mega pick. We have a pretty big regular group that plays on Tuesdays, but Fridays aren't as regular. Usually just Gabby, Wren, and I.
And can you explain a little bit more about how the lottery pool works at Workspace?
I keep a notebook in my desk drawer where I meticulously record everyone's contributions for each drawing. I only accept money for the next drawing to avoid any mix-ups, and I only take cash. You have to get it to me by lunchtime on the day of the drawing.
How do people get their money to you?
Well, I prefer people hand me their money directly, along with a post-it note with their name on it, so that I can record their contribution, check off their post-it note, and hand that back to them. But occasionally, if I'm not there, people will leave money under the Star Wars X-Wing figurine on my desk. But I prefer people not do this because it runs the risk of their money getting stolen. And not to mention, that is a collector's edition item, and I would be very upset if someone knocked it over.
What happens if somebody doesn't have the money to contribute, but still wants to participate?
Oh, I'll take an IOU every now and then from certain players, with the expectation that they promptly pay up. They can do that by giving me cash or buying me lunch. I'll even take one of those amazing eclairs from Lucky's as repayment.
And was there ever an instance where money went missing?
Yeah, actually. It was a Tuesday game, and we had just won a $500 jackpot. When Lewis Medlock claimed that he pitched in, but I didn't receive his money, and I didn't have his name in my notebook. But since it was a Tuesday game and he was a regular player, the other winners and I decided to cut him in.
And were there any differences between the Tuesday game and the Friday game?
Yes. Tuesday we had a pretty big regular group that played, and it was just really a fun activity, sometimes we would go to lunch all together. But Fridays were kind of more serious. It was usually just Gabby, Wren, and I, and not many people played.
Let's talk about the week of June 29th. Tell the jury about some of the events leading up to the winning drawing.
Well, I remember Jackie kept asking Gabby, Wren, and I to cover her for that Tuesday. So I guess she was pretty short on cash. I wasn't going to cover for her because I've had to hound her to pay me back in the past, but I think Gabby covered for her, and I don't know if Jackie ever paid her back.
And do you remember who gave you money for Friday's game?
Yes, Gabby Wren gave me her money, but she was the only one. The only money I received under my ex-wing was Lee Fannon's, with a note explaining that it was for the next Tuesday since he was going to be out of town. But it wasn't unusual that Gabby and I were the only Friday players.
And I'm now retrieving what has been previously entered as Exhibit 5. And I'm showing Ms. Rabideau what has been previously marked as Exhibit 7. Will you please identify this for the jury?
Yes, this is Lee Fannon's note that he left on my desk.
Your Honor, at this time the defense offers Exhibit 7 into evidence. Its authenticity has been stipulated.
Any objection?
Yes, Your Honor, pursuant to Rule 801, this document contains hearsay, and furthermore, Your Honor, pursuant to Rule 401, this document is irrelevant as it is for July 3rd pool, which is a week in advance from the pool we're talking about today.
Your Honor, as to the hearsay on this document, this does not contain hearsay because these are statements that are actually stipulated to be Lee Fannon's, and he testified himself that they were his own on his direct examination. However, Your Honor, we are not offering the statements by Lee Fannon for the truth of the matter asserted. We are only interested in the red check mark on the exhibit, which Ms. Schutze, the defendant, will testify as her own.
I see the document, please.
Yes, Your Honor.
I'm sorry, did I cut you off? Did you have more you were going to say?
Yes, Your Honor. I would like to explain the relevance as Ms. Rabideau.
Let me hear from the plaintiff about the response.
As to hearsay, Your Honor?
Well, as to the response to what she said. Yeah.
Well, yes, Your Honor. Opposing counsel had the opportunity to tender this document on the direct examination of Lee Fannon, and they did not. Therefore, this is hearsay pursuant to Rule 801, as it is an out-of-court statement offered for the truth of the matter asserted. And as far as the defendant's statement on that exhibit, it is still self-serving hearsay under Rule 801.
Your Honor, once again, we are not offering any statements by Lee Fannon for the truth of the matter asserted. Once again, we're only interested in the red check mark on the exhibit, and that is. Yes, sir.
So your testimony is limited. The use of the document is limited to the check mark that you contend was placed on there by the defendant.
Yes, Your Honor, and if you will allow me, I will explain the relevance of that as well.
Go ahead and explain it.
Yes, Your Honor. We are offering this post-it note for the purposes of comparison, because the plaintiff entered a post-it note earlier with a red check mark on it, and they claimed that the defendant had made the red check mark. Your Honor, we are offering this post-it note to show the defendant's customary style of making check marks, because the fact that these two check marks are distinctly different makes it more likely that someone other than the defendant put the check mark on the plaintiff's note, and it makes it less likely that the plaintiff actually contributed to the lottery pool.
Well, Your Honor, if I may close on my objection one last time. Sure. Your Honor, as opposing counsel has argued, there are several differences between the Tuesday and Friday office lottery pools, and the sticky note is from a Tuesday office lottery pool for the following week, July 3rd, and therefore, under their own argument, it is not relevant.
All right. I'm going to allow it. I think that the differences is distinction without a material difference. So I'm going to allow the document to be admitted for the purposes stated by the defense.
Yes, Your Honor.
Yes, Your Honor.
And Your Honor, I would also ask that Ms. Schutze be allowed to step down for demonstrative purposes.
No objection, but may I continue, Your Honor?
Ms. Schutze, will you please explain to the jury what this shows?
Yes, this is a page out of my notebook where I record everyone's contributions for the lottery.
And please specifically explain your notes on the winning drawing.
Yes, as you can see in my excellent penmanship, Gabby and I's names since we contributed for that day. And here's where I wrote Lee Fannon's name, but then scratched it out after reading his note.
And here on Tuesday the 19th, next to Sonny Rawlings' name, there's a red check mark and the word credit. Will you please explain what that means?
Yes, that means I covered for Sunny that day. I would always cover for her if she asked.
And did Jackie Hutchinson contribute to the Friday lottery pool the week before the week of the winning drawing?
Yes, here is her name. Sometimes Jackie would play on Fridays, sometimes not, depending on whether she was short on cash. I don't believe she played the week before that.
Thank you. You may return to the stand. Let's return to the week of June 29th. Tell the jury about buying the lottery tickets.
I remember it like it was yesterday. I went to lunch with Sunny that day, but before we left, Jackie came up to me and was being very rude and obnoxious, saying things like how I'm so unlucky and I'm the reason we never won the lottery. She even told me that she was tired of giving me her $10 and never getting anything out of it. So, from the way she was talking, I thought she never wanted to play the lottery again because of my bad luck. I was so flustered that I left my wallet and Sunny had to cover me for lunch.
And what did you do after this encounter?
Well, later, Gabby and I went to buy the tickets at Lucky's. While we were there, she asked if Jackie had pitched in, and I said no because she hadn't. I handed the lotto payslip to Carrie Chatham and asked for a bag of Chester's fries, which really aren't a part of my diet, but I've just been craving them all day. But she was out, so we just got the tickets and left.
And did anything come of your lottery tickets?
Yes, we won.
How did people at Workspace react to your winning?
Oh, well, most people were happy for us. And of course, being super friendly because we were now super rich. Except for Jackie Hutchinson. I have never seen such a sore loser in all my life. She even kicked Gabby's trash can across the room and decapitated a bobblehead. Someone had cleaned up her mess later, but I did find my notebook and stapler pens out of place on my desk.
And I'm now retrieving what has been previously entered into evidence in Exhibits 5, 6, and 7. Now I would ask that Ms. Shusey be allowed to again step down from the stand for demonstrative purposes.
Objection.
No objection, Your Honor, but now let's get it done.
Yes, ma'am.
Ms. Shusey, I want you to look right here at Exhibit 6. Have you ever seen this note before?
No,
Did you make the red check mark on this note?
absolutely not. That is not how I make my check marks. If you look at Lee Fannon's note, you can see my signature red check mark that I always make the same way. I take the wide end of the pen and I make a good confident swoop, like this. This check mark was obviously made without my signature style or flair, with the little pointy point of the pen, and I would just be ashamed to make that hideous thing.
Objection, Your Honor. Pursuant to Rule 701, it is outside the scope of this witness's knowledge as to what part of the pen would or would not have made, or it is her improper lay opinion, the check mark on Exhibit 6 is she is not a handwriting expert and she does not have under Rule 702 the necessary education, experience, knowledge, skill, or training to be qualified as well.
She would have experience about how she makes it though, right?
Yes, Your Honor. However, she is specifically saying that the one on Exhibit 6 was not made using the point of the pen.
Do you have any response?
Yes, Your Honor. Ms. Shusey can certainly testify as to her own handwriting, and she's entitled to give her rationally based perception under Rule 701A.
I'm not sure about that, but I'm going to overrule the objection.
Yes, Your Honor.
Ms. Shusey, please continue explaining the difference between the check marks.
Yes, as you can see on my notebook, there it is again, my signature red bold check mark.
Thank you. You may return to the stand. What did you do after all of the commotion at Workspace?
Well, Gabby and I decided that we should go ahead and collect the money. She wanted to remain anonymous, so I collected it and was going to split it 50-50. But then I was hit with this lawsuit and had paid off the registry of the court.
Ms. Shusey, did you ever try to cheat Jackie Hutchinson out of her money?
No. Why would I want to do something like that? More money means more tickets and more chances to win. Jackie acts like I knew this was going to happen and had some evil scheme against her, but I can't see the future. I understand she's disappointed about missing out on the win, but this whole thing is just ridiculous.
Thank you. Your Honor, I have no further questions.
All right, your cross, ma'am.
Yes, Your Honor. So now, Ms. Shutzy, on direct examination a few minutes ago, you mentioned that this is not the first time that the lottery pulls hit the jackpot, is it?
No.
In fact, the first time you won, like Jackie, someone else told you they contributed. Correct?
Yes, but unlike Jackie, this person always contributed to the Tuesday game because Lewis Medlock was a Tuesday regular. Like, Jackie doesn't usually play on Fridays, so it's kind of different.
But nowhere in your sworn affidavit did you state that being a regular in the Tuesday game and being a regular in the Friday game are two completely different things, right?
No, I didn't, but they're two completely different days.
So now because of the situation, you held a vote with the other members of the pool, right?
Yes, they decided that we should cut them in since it was a Tuesday game and we just played for the fun of it, and we had decided that if we ever won, all the regulars would split it. So it just made sense.
Well, you cut him in even though he had no name in the notebook.
Objection, Your Honor. This is a propensity use of this information, as they're trying to show that because this happened in the past, it is more likely that it happened in the future. And furthermore, Your Honor, I believe that by this information, Ms. Rapido was trying to show that there was an agreement where regular lottery players were covered without contributing cash to the lottery pool. And earlier in this trial, Your Honor, you ruled that that was outside the scope of the
So what is your objection?
to this information being used to show that there was some sort of covering agreement and that this is a propensity use.
Well, Your Honor, if I may proffer once again. Your Honor, we proffer that this witness will testify as to the differences between these two scenarios and her relationship with Jackie Hutchinson, therefore showing her bias in her not treating Jackie in the same manner that she previously treated this participant under Rule 404B2, going to show her motive and intent.
So do you have a response, ma'am?
Yes, Your Honor, that is a propensity use because they're trying to show that because it happened this way in the past, that should have been how it went.
So what rules specifically are you objecting using?
Your Honor, this would be under Rule 404.
404 that deals with character?
Yes, Your Honor.
Okay, objections overruled.
Yes, Your Honor.
So you cut him in despite the fact that he had no name in the notebook, right?
Yes, that wasn't really my decision. We all just took a vote.
And you cut him in despite the fact that he had no sticky note with the check.
No.
You cut him in, as you mentioned, because he's a regular, right?
Yes, we all decided that that's what we should do.
Jackie's a regular.
Not on Fridays, she's not. She's regular on Tuesdays, but this is a Friday game. She almost never plays on Fridays.
But still, even as you admitted just a moment ago, you never put anywhere in your sworn affidavit that there's a difference between being a Tuesday regular and being a Friday regular.
I didn't feel like that was necessary, but on Tuesdays, we have a big regular group, and on Fridays, we don't.
You signed your affidavit stating that you had nothing of significance to add, right, Ms. Shetson?
I didn't feel like that was necessary to add, but I'm saying right now that
Objection, Your Honor. Witness has answered the question.
Your Honor, I'm just clarifying because the witness continues to give me the same answer going outside the scope of her affidavit.
Objection is overruled. She's got her own cross, and the witness needs to answer the question that's asked.
Yes, Your Honor. Ms. Hutchinson, Jackie had her sticky note, right?
not to my knowledge.
But you still have a pink sticky note sitting right in front of you, right?
I've never seen that before. She probably made that note.
Objection, Your Honor, pursuant to Rule 602, it is outside the scope of this witness's knowledge as to whether or not Jackie made the note.
Your Honor, Ms. Rabideau opened the door for this testimony in asking Lane Shutesy about the post-it note. Lane Shutesy testified that she's never seen it before, so surely the plaintiff must have made it.
Your Honor, I simply asked this witness whether or not she had a pink sticky note sitting right in front of her, and she does right now. Therefore, this was outside the scope of my question and outside the scope of her knowledge pursuant to Rule 602.
Objection sustained.
Yes, Your Honor, move to strike.
Motion granted.
Yes, Your Honor. Now, you did not hold a vote concerning Jackie, did you?
No, because this is a completely different situation.
But there are also two big differences between these situations, right?
Yes.
And that's how much you won, correct?
Yes, that is different, but the main difference is that we don't cut people in on Fridays.
But you never put anywhere in your sworn affidavit, once again, that you absolutely do not cut people in on Fridays, right?
No, but it's implied that the Friday game is different.
But you still never explicitly stated it, correct, Ms. Hudson?
I didn't feel the need to. It was definitely implied that Jackie rarely plays on Fridays, and Fridays we don't have a regular big group.
Well, still, the first time you won it was a $500 jackpot.
Yes.
And this time, it's $120 million, right?
The size of the jackpot doesn't really matter. What matters is that Jackie didn't contribute.
But the answer to my question is yes, this time it's $120 million, correct?
Yeah.
And so, the other difference is who's telling you that they contributed, right, Ms. Hudson?
I guess, but that doesn't really influence any decision.
You claim it doesn't influence any decision. Well, let's talk about how you feel about Jackie Hutchinson. You've called her a racist fool, haven't you?
I did say that in the heat of anger one time when she was being very rude to me.
You've called her an inconsequential person.
I do say that because I try not to let her grudge and hard feelings get to me.
Ms. Schuetze, you believe that Jackie's been stealing clients from you, right?
A few clients do go to Jackie as opposed to me, but that's okay. I can afford it.
You claim it's okay and that you can afford it, but in your own words, it feels like she's taking money right out of your pockets, correct?
Yes, but like I said, I can afford it. I even refer clients to Jackie sometimes when I feel like that she can meet their needs better than I can.
Never mentioned anywhere in your sworn affidavit once again that you refer clients to Jackie, correct?
No, it wasn't necessary.
Now, as you mentioned, you're the commissioner for the office lottery pool.
Yes, I organized it because I thought it would be a fun activity for us.
So you control the funds for the pool.
I don't really control them. The people that contribute, that's where the funds come from.
Well, you will admit that you are the only person that comes in contact with the participant's money from the moment they hand it to you to the moment you hand it over to the cashier at Lovejoy's, right, Ms. Shetson?
Yes, and that's exactly what I do. I use their money to pay for the tickets, and that's it.
You control what's written down in that lottery notebook.
Yes, and I am very meticulous with the records. I always record everyone's names and everything.
And you control giving people back their student notes.
Yes,
You control buying the ticket,
I do.
and you control what money is used to buy that ticket, right?
Yes, all the people at Workspace trusted me with their money, and I did what I was supposed to with it.
Now, following your conversation with Jackie the morning of June 29th, you believe that she reported you to the lottery authority, right?
I did suspect that because she mentioned something to me about it.
You were investigated by the lottery authority, weren't you?
I was, but they didn't find anything.
Objection, Your Honor. This information is improper character evidence under Rule 404.
Your response?
Your Honor, the door to this evidence was already opened on the direct examination of Ms. Hutchinson, and furthermore, Your Honor, opposing counsel did object to this on the direct examination of Carrie Chatham, and at that point, you overruled their objection.
So I don't need another response. The issue's already before the jury, and so it's a proper issue. But I'm not sure that the plaintiff can open the door for something that's improper. So not for that reason, but I do overrule the objection.
Yes, Your Honor. You were investigated by the lottery authority, weren't you?
Yes, I was, but obviously I had not participated in any of the illegal cash payouts that the investigation was about, so I'm all in the clear.
You might be all in the clear, but you were still audited, weren't you?
Yes, they just wanted to be very thorough, and I respect the lotto authority on that. But it was a little inconvenient since, I hadn't participated in these illegal activities.
Part of the reason it was inconvenient was because you had to answer questions from the Department of Revenue, right?
Yes, I did.
You had to send in your W-2 form stating back 3 years, correct?
I did. It just seemed to much ado about nothing to me.
But you'll still admit it was a huge pain for you, wasn't it, Ms. Shetson?
It was, but it's in the past.
Well, you claim it's in the past, but you'll admit that just hours before you went to go buy that winning lottery ticket, you were mad at Jackie about it, weren't you?
Oh, I wasn't mad about that. I was more mad about the fact that she was being really rude to me and calling me names and unlucky.
So it's your sworn testimony today that you never put in your affidavit that you were angry at Jackie because you believe she reported you to the lottery authority.
I was irked because she was being very rude to me that day.
No further questions, Your Honor.
Any redirect?
No redirect, Your Honor. May the witness step down.
Yeah, thank you, ma'am.
And Your Honor, at this time, the defense rests.
So I'm sure it's written somewhere and I've overlooked it, but I've been looking for the rule on closing argument and I can't find it. Does the plaintiff wish to open and close or just close?
Your Honor, pursuant to Rule 12E, the plaintiff does wish to present a closing argument, but we waive our right to open and reserve all time for rebuttal.
So I'm interpreting what you said is that you had the right to do both, but you're waiving. But I'm gonna find the rule and I'm gonna read it. So it doesn't really matter though. Is the defense ready for your closing argument?
Yes, Your Honor. But before I begin, may I retrieve the exhibits I will be using?
Yes, ma'am. Okay. So I found it. Wasn't where I thought it would be.
No name in the notebook plus no post-it note with a check mark equals no money. Those aren't Lane Schuetze's words. Those are the words of the plaintiff on cross-examination, showing that she understood that the lottery pool worked precisely as Lane Schuetze told you it did today. Now in a few minutes, Judge Gray will charge you on the law in this case, and he will tell you that a contract is an agreement between two or more parties to do or to not do some specified thing. So let's talk about the evidence you heard during this trial, because you didn't hear from any credible witness that Lane Schuetze ever agreed to split lottery winnings with players who did not form an express lottery agreement with her. Lane Schuetze testified, and she told you that she never received money or a note from the plaintiff for the June 29th lottery pool. The plaintiff even admitted that she never received the confirmation that all the witnesses agreed was Lane Schuetze's way of acknowledging lottery payments. The return of the post-it note with the red checkmark. Even more telling, the plaintiff never even checked to see if Ms. Schuetze had received her money. Important things get checked, and not after the fact. Now, the plaintiff can try to claim that Lane Shootsy deliberately did not record her contribution because she didn't like her or because they had an argument. But that doesn't make any sense when you consider that 1, the plaintiff and Lane Shootsy had never gotten along, and yet Miss Shootsy recorded all of the plaintiff's previous contributions. And 2, and most importantly, Lane Shootsy could not have known that she was going to win the lottery that day. Is the plaintiff honestly claiming that Lane Shootsy tried to cut her out of the winning pool before they won? Defense witness Gabby Wren testified today, and she told you that the plaintiff actually had to borrow money from her for the Tuesday pool. This confirms that players had to ask to be covered, contrary to what the plaintiff told you today. What else did Miss Wren tell you? She told you that on Friday, the day of the drawing, she heard the plaintiff saying that she still needed to contribute, directly contradicting what the plaintiff told you, that she put her money on Lane Shootsy's desk on Wednesday. Lee Fannin also testified today, and he told you that when the plaintiff kicked Gabby Wren's trash can after finding out about the big win, he cleaned up all of that trash and placed it in a new can, and placed that can outside Lane Shootsy's cubicle. Why is that important? Well, the plaintiff tried to claim today that she found her note in a trash can outside Lane Shootsy's cubicle. But the can she's talking about contained Gabby Wren's trash, not Lane Shootsy's. And the plaintiff's other witness, Carrie Chatham, wasn't even at workspace when any of the events occurred. All she can tell you is that she heard Lane Shootsy make a joke while she was buying the lottery tickets. She couldn't even hear what Lane Shootsy was saying because she admitted that Miss Shootsy was mumbling. Carrie Chatham is the plaintiff's friend. The plaintiff even told her she would share some of her lottery winnings with her. She is not a reliable witness. Now I want you to look closely at that note that the plaintiff presented today. There is a red check mark on it, but I want you to double check it. I want you to look at Exhibit 5 and at Exhibit 7. Both contain Lane Shootsy's signature check mark. It's distinctive. It's made with the wide edge of the pen with an arc. Now look at Exhibit 6. That check mark is different. Why? Because it was made by somebody else. And there's only one person who had the motive to fabricate that note and that check mark. The plaintiff. And if she fabricated that evidence, how can you be sure of anything that she's told you today? Members of the jury, the plaintiff told you today all about the range of emotions that Ms. Hutchinson experienced when she found out about the lottery pool winning. Joy, excitement, anger, despair. But members of the jury, that's exactly what we would expect from her. Because she first found out the lottery numbers had won, and then realized that she missed out on $40 million. Members of the jury, I'm sure the plaintiff regrets not playing the June 29th lottery pool. She may even feel entitled to some of the winnings because she's played in the past. But those are not legal claims to the money. The plaintiff has not met their burden of proof today. And because they haven't, I'm asking you to return a verdict in favor of the defendant, Lane Shootsy. Thank you.
All right, can we begin?
Yes, Your Honor, but may I have a moment to set up the courtroom?
Certainly.
May it please the court, opposing counsel, members of the jury. Her joy, excitement, and elation turned to confusion and shock, then anger and despair. Within seconds, Jackie Hutchinson experienced this range of emotions as the defendant wrongfully deprived her of $40 million. Now, in a moment, Judge Ray will explain to you that to constitute a contract, there must be an offer and acceptance, consideration, and the mutual assent of the parties to the terms of that contract. Now, we have gladly accepted and met our burden to prove to you each of these elements by a preponderance of the evidence. Thus, you must find the defendant liable for breach of contract. Now, it has been widely undisputed by the defense that there was an outstanding offer from the defendant to every employee at Workspace to be entered into the Tuesday and Friday office lottery pools. It was also shockingly undisputed that to accept that offer, the employee would then provide consideration by either giving their $10 directly to the defendant or by leaving their money on the defendant's desk with a Post-it note attached. Now, everyone who played the lottery, most importantly, the defendant, understood and mutually assented to those terms. Now, the evidence has been crystal clear. Jackie accepted the defendant's offer to play the lottery. Not only did you hear it directly from Jackie, but you also heard it from Miss Rawlings. And you even heard it from the witnesses from that side of the court, including Miss Wren, but most importantly, the defendant, when she said that Jackie's note got lost, and it serves her right. But why was there only $20 in the pool that Friday? The answer, $10 did come from Gabby, but the other 10 came from Jackie. How do we know that the defendant did not contribute? Well, it's simple. She had no money, either at lunch shortly before the ticket was purchased or at Ricky's Sports Bar and Grill shortly thereafter. But I know what you might be thinking. Isn't the defendant an architect? Shouldn't she have plenty of her own money? Maybe. But as Ms. Chatham told you, instead of working, the defendant likes to waste time and money playing the video poker machines at Lucky's Grab and Go. Now, the defense is just not correct. Important things get checked. We're talking about sticky notes. And the interesting about that is, the moment Jackie left her $10 on the defendant's desk, the contract was complete. Thus, I'm sorry, but these two documents are practically irrelevant. And I ask that you listen carefully to the jury charge, which Judge Ray will read you in just a second. I understand it might be long and winding. I want you to listen for 2 words very intently. And that's receipt, and that's confirmation. Because I'm going to go ahead and tell you now, you're not going to hear either of those words come out of his mouth because they're simply not required to constitute a contract. Now, one more thing. Gabby Wren and Lane Schuetze were sitting up here. Did you once hear them state that the defendant checked a sticky note for her? She was in that Friday lottery. Did you once hear her state that she got a sticky note back? No, because they're just not important. Now, on July 2nd, 2018, the defendant's actions caused Jackie's emotions to change from joy to despair. Today, on March 16th, 2019, we ask that he give Jackie a feeling of relief, a feeling that true justice has been served. We ask that you return the only verdict in today's case that speaks the truth. We ask that you find the defendant liable for breach of contract. Thank you.
All right, so with closing arguments completed, the jury is instantly instructed on the law without further ado. And so where that leaves us is that this trial is over. There'll be no more lottery conflict, no more workspace questions, no more pink sticky note questions ever. So I think the participants deserve a round of applause. So I'm going to ask in a minute for the jury to retire to the Dunlap room for purposes of completing your score sheets. I do want to remind you that in addition to doing that, that you will also need to discuss Best Attorney, Outstanding Attorney, and Outstanding Witness Award. I'll remind you that you're to complete your scoring individually before discussing any of the awards. And then 10, 15 minutes or so, maybe even shorter, we'll return to the courtroom and we'll have a few comments for the participants. So you can retire at this time. If I could close the door, perhaps. Thanks. So as the jury has retired, I'll first ask the plaintiff, do you believe that there's been any material rules violation that's occurred during the course of the trial?
No, Your Honor.
To the defense, do you believe there's been any material rules violation?
No, Your Honor.
All right, so I'm gonna make just a couple of comments, and then I'm gonna go join the jury, and then we'll be back in a few minutes. So I feel really foolish giving two teams that have made their way through the regionals and districts to the finals with any critique at all. And there's a lot of good that I can tell all of you. And what I'll say about that is that maybe it didn't feel like it at the time, but it looks like you enjoy it. So, I hope that you'll consider law school. If you think that it might be of interest to you, obviously before that, you got to graduate high school and you got to go to college. And I want to tell you, you don't have to be a pre-law major. There really isn't really a pre-law major. There's subjects that you might be directed to. English is a big one because you got to know how to write to be a lawyer. Probably it's more important to know how to write than it is how to do anything else, honestly. But I would encourage you to do something you enjoy. You don't know if you want to be a lawyer. You may change your mind about being a lawyer. I did. I got a different graduate degree before I went to law school because I wasn't sure I wanted to be a lawyer. And I ended up going to law school, obviously, but do something you enjoy. And particularly if that's technical or scientific or math related, because that's where our world is. I serve as a judge, a federal judge in Atlanta, a trial judge, and everything is computer driven. The lawsuits that I see almost always have computer components, no pun intended, to the case. And so that's where the world is. And so if you like that kind of stuff, then do it and then go to law school. One of the interns that's going to work for me from UGA this summer has a physicist degree of some sort from Georgia Tech. And I jumped at the opportunity to have her come work for me this summer because I have so many cases that deal with the kind of stuff that she knows a lot about because she did that in school. And then if you want to go to law school, then go. It's a great profession. If you like what you're doing, as those of you particularly that are being the lawyers, but the witnesses may be the same for you, then you'll like being a lawyer probably. So, give strong consideration to it. And I'll just tell you, there's not a better law school than the one that's right here in your home state, particularly when you consider what you have to pay or don't have to pay. My son's in law school somewhere else. I failed. I tried to get him to go to Georgia, and instead he wanted to borrow a lot of money and go somewhere else. But I assure you, he's not getting a better education where he's going than he would get here at the University of Georgia. So just two quick constructive comments that I can give you that really applies to both sides. The first thing, one of you is going on to nationals. Hopefully both of you will. I guess that's something that we might know later, whether Georgia will have an additional entry. I would say to both sides, you got to learn how to control the witnesses for the other side because you're giving them too much of an opportunity to say the stuff that they want to say and not the stuff that you want them to say or not say when you cross-examine them. Because cross-examination is where, really, in real law, it's where you win the case often. But you're not going to win in real life if you allow the witness to basically say whatever they want to say, because you get to ask leading questions and you get to control it, and you can ask the judge. It happened once in this case, but you can ask the judge, Judge, she's not answering my question. I asked that you make her answer my question. Now, that doesn't mean that in some proper times that the witness may get to explain their answer, but I listened to all of you, and I would say 95% of the time the witnesses really weren't answering the question. They were answering the question that wasn't asked. And so get a handle on that. Think about that as you get ready. I know it's going to be a whole new problem, but that issue will still be there because witnesses are trying to do their best to say the stuff that they want to say. And the other comment I would make is this. When you object, it's not a war, so you don't have to be really, really loud and jump up with all this energy, even though you're feeling it. You're like, I got to get this out there, you know. The problem is that in real courts, you run the risk of making the judge and or the jury upset because they think you're mean. And in mock trial, you just are too loud. And you want to be likable to the judges, which is what the jury is, too. And so I don't know how to tell you to do that. But probably the only thing I can say is if it's not the same conversational tone that you would use with your friends in your home or elsewhere, then it's probably a little much. But look, folks, those are nitpicky little things, and y'all, are very, very good, and I'm proud that you've made it to the finals, and I look forward to seeing who wins. I frankly have no idea who's going to win, and the good thing is I don't have to have any decision in that. So we'll be back in just a few minutes.